Maniac Monday. Oh my God. It was a crazy court day. I'm speechless. I have a stack on my flash drive. Don't know where to begin. So, what I'm going to start with is saying hello to everybody. Thank you for tuning in. I found new video editing format, and the outpour of views is ridiculous. People love it. I think we're gonna go with Time Served Productions for a little while. Polls up. Who do you prefer, Judge Bryant or Judge Phyllis Webster? Who do you prefer? Well, we got them both. But speaking of maniacs, this was not today. I wanted to show this one the other day. This one is just makes me pissed. And then I got another one from my page that is instant classic. And then we'll roll with everybody else. So let's get going.
All right, let's go back on the record then. And it looks like Ms. Westerbeer is here from the department. Ms. Westerbeer, raise your right hand. Do you swear or affirm any testimony you give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and I've got Ms. Roselle and Mr. Rose, it's editor now, and Mr. Rose on the record here regarding a hearing. And Ms. Utter had filed a motion for an ex parte order to suspend Mr. Rose's parenting time with Caden and Jaslyn. And she was basing that on a CPS complaint. Can you give me more information about that?
Yes, so I'm currently investigating some concerns of sexual abuse. The allegations state that Jaslyn had disclosed that her father had been touching her vaginal area, and then had also walked in on her little brother touching her dad's genital area as well. The investigation is still ongoing. We did a CAC interview on Monday for both of the children. There were no disclosures from Caden. And Jaslyn did make a disclosure that her dad had touched her vagina, but there weren't many accompanying details as to the circumstances or what was going on. Myself and Trooper Vandervloek with Michigan State Police interviewed Nathan on Tuesday or Wednesday. I have to look back at my notes. I can't remember exactly which day. It was Tuesday or Wednesday of this week. And he denied the allegations. He is willing to do a polygraph, so we're waiting for that to get scheduled as well. And then we have a home visit scheduled with him for Monday at 3:30. So at this point, my investigation is still ongoing. I do have concerns, but I think once we are able to do that polygraph, and I did request medical records for Jaslyn, and I only recently got those this morning and haven't had a chance to review them just yet.
All right. Ma'am, do you have any other questions for Ms. Wester?
No, I do not.
Sir, do you have any questions for Ms.
What's up,
Wester?
Toby?
Nope.
And sir, you're gonna be taking a poly when it's offered?
Yep.
And Ms. Westerbeer, you said that could be on Monday? Is that what you said?
We have a home visit scheduled at Nathan's home, myself and the trooper on Monday. But the trooper was going to be getting a hold of whoever he needed to discuss scheduling that. But I didn't get the impression that it was going to be an issue to have it scheduled. We just don't have a specific date yet, but I can follow up with him on Monday. I know he doesn't work on Fridays, but I can follow up with him on Monday to see when that might be happening.
All right. Sir, are you opposed to an order then suspending your parenting time while this is being investigated?
Yes.
You are opposed to that? What if it was suspended, but I would indicate in the order that if this is all cleared up, that you'd be granted makeup parenting time for any time that you missed?
Yeah, I can.
All right. I think it's safer kind of globally for not only the children if something is going on, but for you if there's nothing going on, but your daughter's saying there is something, because I guess if that's the case, then there is the potential that she could say more and open you up to further scrutiny or criminal liability. If a polygraph can clear this whole thing up, then that's great. But then we got to take the next step to figure out why a child might say something that is determined not to be credible. So I think for the safety of everybody involved, including your legal rights and things like that, it probably makes the most sense to suspend parenting time until the CPS investigation is concluded, with the provision that you'd be granted makeup parenting time if it is dismissed without any further action or indication of wrongdoing on your part. All right?
Okay, sir.
All right. So on an order to that effect, I'll set it for review in, I don't know, 2 weeks. Ms. Westerbeer, is that enough time to get everything done, you think, or maybe a month?
I know I have 30 days to do the investigation, so I'll have at least 3 more weeks. It's honestly going to come down to when we're able to get that polygraph scheduled. So I would say maybe, 2 to 3 weeks, unless something changes.
All right. How about if I do May 26th at 2:30? That's 3 weeks from today, 3 weeks from right now. Sound good?
Let me quickly just double check. That should be, yeah, I mean, that should be enough.
Okay. All right. I'll see you guys back here then. If everything is cleared up in the interim and that hearing becomes unnecessary, you could call the clerk and have it canceled. Otherwise, I'll put it on the calendar and plan on seeing you guys on the 26th at 2:30. All right?
So
This guy is
Yep.
El
Sounds good.
Creepo.
And Your Honor, if the polygraph is scheduled after, if they have scheduled for after the 26th, did you want me to get a hold of the clerk and let them know?
What's that now? I'm sorry.
All right. Here's one from my girl. My crazy life. Lucy sent me one too. Somebody else played it already, so I'll get it in. I'll work it in. All right, here we go. This is funny.
I'm ready when you are.
Okay. Okay. I need Hicks out of that. I don't even have this. Our first case was Jocelyn Charleston. Case number 23-0666. The people of the state of Michigan versus Joyce Charleston. For appearances, please.
I'm gonna need a minute. God damn it.
You're on recording.
I'm not.
I'm just saying your sentiment though, because this is crazy.
Yeah, Zoom is acting like a nut. My internet's acting
Yes,
like a nut.
I had to
Good
go
morning,
in backwards
Yeah.
for Zoom today. I don't know if maybe the whole building.
Good morning, Your Honor. John KCP number 56162 on behalf of the people.
If it please the court, Attorney Sharon Jones, P number 57113 on behalf of Mrs. Charleston, who is present.
Ms. Charleston, say your name for the record.
Jocelyn Charleston.
Thank you. This is a
Oh, here we go. We got a Carney number 2. Mike Page with the Carnies.
We're on the record. Ms. Heaven, you want to call the cases?
Oh, this one's a
Case
classic.
2013-052214, Consuelo Kemper versus Christopher Kalida and the department. This is an arrears only case. She's ordered to pay $50 a month.
Ugh.
She currently owes the state $1,575.90. Fees $524, total owing $2,099.90. There are prior contempts. This is a fail to comply issued February 9th, 2023, 45 days or $500 cash bond. She was brought here from Mecosta County Jail on May 5th, 2023. And we also have case 2018-055942. Agency placed foster care versus Consuelo Kemper. And this is also a $50 a month ordered on arrears. Yeah, I'm sorry. I don't have. Bear with me just a second. This is, she owes $570.49 to the state, $399.50 in fees, totaling $969.99 on that case. Last payment for both was in May of 2019. And for some reason, my thing did not print right for the 2018 case. I'm sorry. 2013, we received $196.33 in May of 2019, $114.53 in April of 2019, and $11.10 in 2018. In 2018, the last payment was in May of 2019, and that was $25.48. Prior contempts in both.
45, 500 on both?
Correct.
All right. And ma'am, I'm the referee of the court assigned to handle these matters. At the conclusion of this hearing, I'll make a recommendation that'll become a court order. You do have the right to have a lawyer. You wish you could hire one, or I could appoint one for you, or you could proceed without and represent yourself. Do you know what you'd like to do?
No, I don't.
You don't know what you'd like to do?
I don't have enough money for a lawyer.
You want me to appoint one for you?
Yes.
All right, I'll appoint you a lawyer. Ms. Heaven will contact that lawyer. And
But I actually
we'll let
have
you know.
a question.
Well, hold on, let me finish here. Don't interrupt.
Yeah.
She'll have you brought back over and we'll have you hearing when that lawyer is available. Question.
Is there any way we can finish this today? Because like I was just telling her, I just found out about this just right now. And I only didn't pay the payments because my mother was sick.
Hold on. Do you want to have a lawyer or not? If you don't, we can.
No, it's fine to not have a lawyer.
Okay. So
Proceed.
Ms. Heaven outlined the amount that you owe child support. Do you agree that you owe those amounts?
Yes, I agree. I owe those amounts.
Okay. And you've
Why
not
it
made a-
hadn't
you've
been
not made a
paid.
payment in 4 years, is that right?
It's been one thing after another, sir. The last time I was in here, my mom was severely sick. Since then, she has passed away. I just missed her burial last Saturday. Day before yesterday, we just buried my mom and I wasn't able to make it. I have a job with Native American Amusements in Battle Creek waiting for me. I can have my boss send you guys my whole paycheck if I'm able to get let out. Because my fiance's already arranged for me a ride back to Battle Creek.
Stop banging.
He can't pay my bonds now.
How much could he pay?
He's not gonna be able to pay any of it because he has to pay to get me a ride back there. I can pay you guys $150 within a week. And that is within a week. And
So, ma'am, your bond is $1,000 total, 500 between two cases. And you haven't made a payment in 4 years.
I'm saying I can pay you guys $150 towards my fees in a week and then make an average
$50 a month, owes $1,500 and hasn't paid it in 4 years. And she's still trying to get out of it.
$100 a month to you guys every single month.
Where have you been working the last 4 years?
I
Thank
haven't
you,
been
Chris.
working because I've had issues with my health. I've had issues with my family members getting sick. Like I said, my mom just passed away in September of last year. We just buried her yesterday and I had to miss it.
Well, that's unfortunate, but it's your own doing. You have a child support order to pay on arrears and you've not paid it. It's not like you haven't paid it in 4 months. We're talking 4 years. You can't tell me that in the last 4 years.
I understand that. I completely understand that.
To make one
And
payment. You haven't paid anything.
I am, like I said, my job's lined up. It's just waiting for me to get there. It's a year-round job. It's not like the carnival's there and then they're gone and then it's done. It's a year-round job. I can travel with the carnival.
Okay.
And I will make sure the payments are made.
Why haven't you made an effort to-
job,
Imagine her serving you a corn dog. Ugh.
just so you know.
Why haven't you made an effort to find a job though in the last 4 years to be able to make payments?
Mac and cheese.
I've been homeless. I've been in and out of jail in Battle Creek.
For what?
Mr. Blake.
There was a retail fraud for one of them, but I'm done with all that. Like she was saying, this has been in the lien since February. I just now found out about this yesterday, or not yesterday, today.
All right, well, that may be, but you could have assumed that you had a warrant if you hadn't made a payment in 4 years on your child support. This is not our first song and dance. You've been in front of me before for many things.
Correct. I'm not gonna be in front of you again, and I can promise you that.
Yeah.
All right, well,
All right.
now you'd had some jobs that you had talked about previous times when we had child support hearings. I think you were working at Subway one time, you were working here and there. What happened to those jobs?
Those fell through. A couple of them, they were under the table with friends, and
Subway fell through. Subway fell through. This is such a funny clip, and that's the funniest line. It fell through.
I never got paid. I've been more or less couch surfing with friends right now. I'm staying with a friend at 11 Culp Court. But I'm willing to take my whole check from Native American Amusements and send it to you guys if I'm able to be released today.
Will they advance you some of your wages?
No, they will not. But
Okay.
I could get paid within a week.
How do you know they won't? How'd you get the job?
It's my fiance's there.
Darkova.
I've already asked him if he can send somebody up here, and he said that he could not. That I would, because of the issues that my son has given, or my son, listen to me, that my fiance has given him. He said he will not pay me in advance, but he said I would get paid within a week.
Well, it's my firm belief that you've had the ability to work over these last years. You've failed to make payments. I'll lower the bond so you only have to pay $500 instead of $1,000. So 45 days on each case would be imposed with a $250 bond. You'll either serve 45 days, or if $250 is paid on each case, then you can be released.
Can I please?
Not the judge. You have
Can
the
I
right to
please
the
get
judge.
out today? My mom just got buried yesterday.
Well, that's unfortunate.
And
but-
I have a job lined up and everything. I'm being real with you guys, please.
Okay, I understand that.
Because I'm going to lose everything I own if I don't.
Well, if it's your fiance's dad, I'm sure he'll hold the job for you. So
No, not the job. Everything I own, my clothes are going to be gone. Everything.
well, your friends wouldn't do that to you.
Yes, they will. They're supposed to be getting kicked out. I can send you my
Darkova. rain. Grab your memberships. Thank you, Darkova. Much appreciated. You missed the puppy birthday. You're all about Maddie.
Full paycheck.
Oh, maybe they'll pay your bond then. So you can
They're not
object to
going
my,
to.
you can object to my recommendation, have the hearing with the judge if you wish, or you can accept it. Do you know what you'd like to do?
Can I please get out today? Nobody told me about this until now.
You've known about this obligation for years.
I feel like I'm gonna pass out.
Well, you might, but.
You might.
And the deputies will be in there. You've known about this obligation for years.
I feel like I'm gonna pass out.
Well, you might.
Can we get it up for Mike Page being an absolute jerk off today? Absolute jerk off to her. Much deserved.
But the deputies will be in there and they'll provide medical care. But do you want to object to my recommendation or do you want to accept it?
There's no way that you can just let me out. I can stay in Mecosta County and live in Big Rapids if I have to.
Ms. Evans, she hasn't answered the question. I guess set up a hearing with the judge.
Okay.
You're all set for now.
Oh, come on. What is wrong with this country? Oh my God. Do you know Score Jail has no justice at all? No justice. Here we go.
James Draper.
Yes, so we've heard Mr. Draper's case already.
Well, we were told to dial in at 1:30 and we were here at 1:30, and why was he already here before 1:30?
Nice haircut, dude.
Well, we went on YouTube at about 1 o'clock.
We talked to the Des Moines clerk this morning at 9 a.m. She told us to call back at 10. She would talk to the prosecutor. Prosecutor said, yes, because we are victims, we would have time to make a statement in court in front of the judge and the district attorney. But now we dial in when we're told, and you say you've already processed this case. Is that fair to us?
This was on for a review. It was not on for sentencing. What did you want? Do you want to see if we can get Mr. Draper back? Well,
you've already dispensed your justice, haven't you?
Well, I'm sorry. What is it you wanted the court to know about that case?
It should have never been brought. We've been fighting the district attorney from day one to drop it, and finally got a judge to drop the.
Does he have a Scrabble? Is that Scrabble artwork? And will you dispense justice? You already did? You dispensed your justice already?
No contact order.
No contact order, and my wife invites him into our house and you arrest him for it. So it's like he was set up for this crime and now you continue to punish him.
Set up for the crime.
So what was the outcome of today's proceedings? We weren't privy to.
Well, you can go back and watch it on YouTube, but there was a new criminal conviction. And so the court had imposed 10 days in jail with credit for 3 days served, meaning that he would be out in approximately probably 3 days.
And what is the conviction for?
Illegal use.
The underlying, let's see, on Mr. Draper's case, the underlying conviction was for violating a no contact order with a violation date of, let's see.
August 17th, 2021, Your Honor.
And that's the date that I invited him in the home to take a shower. So that conviction should have never been brought to justice in the first place.
We were told by the prosecuting attorney that it was dropped.
That is Scrabble. Okay. That's cool. What does it say? James, Mark. Oh, all right. Cool. All right.
Right.
Pretty
My
cool.
daughter is actually the one that called the police. She was not even living here at the time. She
Is he
was
drinking Ovaltine?
also visiting
Definitely.
from out of state.
Well, I don't see that there is any active, currently any active no contact order as far as I can tell.
That's correct.
So at this point, it is a conviction. If he wished to, I mean, he'd have to talk to his attorney if he wanted to take any action on that.
Thanks,
But at this point, it was just here for an alleged violation of probation.
So another notch in the prosecutor's gun belt when he wants to be a politician, he can say he's got another conviction on his record. And to heck with the truth and justice.
All right, well, I've tried to explain to you procedurally what occurred.
It's a TPO, dude. The prosecutors are prosecuting a murder of 3 people. Like, really? Come on. Go cut your hair.
If your issue is with the initial prosecution of it.
He has that old gray, smoky, silver, yellowish hair. The one that's like, looks gross. Not like salt and peppery silver fox. That's like the gross kind. I don't know.
It's with the whole thing. And you continue to punish him for a crime he didn't commit. Now, today it's 10 days. What's it going to be next time? You're going to give him a year next time?
Well, we're not going to relitigate at this point.
Well, who
Yeah,
pressed?
Ms. Stahl is
Who brought the charges against him?
the
We
city
didn't.
is the plaintiff. That the city is the plaintiff. I'm not going to argue on the record. We can. My clerk Andrew can give you the phone number for his defense attorney if you'd like, and they can chat with you more.
We
about-
spoke to your clerk this morning, and this is what we get. It's like you guys did a bait and switch on us real quick. So we have no input.
Well,
You-
what I can tell you, what I can
Newsflash, mustache. Nobody cares.
tell you is that what was before the court, that I hear what you're saying, but what was before the court is not whether or not the case was going to be pursued or dismissed. The only issue for the
No, so this was, they were so-called victims, okay? So they were going to put a victim statement. So supposedly the guy was invited into their home by them and took a shower. And then something happened where the daughter called. Now, what wasn't clear is whether the daughter and him were boyfriend and girlfriend, or they are, I think he's just a friend that they were helping out. But they're thinking, from what I get, they're thinking that he's getting charged for taking a shower in their house and everything, but the judge is trying to say it's a new charge. And then he's just saying the prosecutor needs a notch on his belt. Big goings on in Des Moines, Washington.
court today was whether or not there was a new criminal law violation.
See?
Of failing to appear on this bogus charge.
No,
Yeah,
it was
see?
a theft conviction out of Tukwila.
There it is, and a theft conviction. So, yeah. Hey, he's a nice guy.
So is that what he was arrested for 3 days ago?
What I think happened was Silver Fox over there and Mary wanted to have a little throuple, let him take a shower, and the daughter called because she found the Astroglide. That's what I think.
No.
He was arrested because there was a warrant out on this case, but the reason there was a warrant was because he didn't previously appear at his hearing in our court. And in the interim, he picked up another criminal law violation. So that's all I'm going to say about this case now. You can certainly reach out to the prosecutor and the defense attorney if you have further questions or issues.
Yeah, they're probably looking to put more charges on them so they can get more.
All right, let's move on. What's our next case?
Can we address Leanne, Your Honor?
Oh, yes. All
Oh,
right.
and then this one, yikes, we're coming back to her. Scary Mary over there. So, all right, let's go. All right, so this one I wanted to show you. So in Kirkman, this was a big case of a teacher and a student, and he got thrown in jail for statutory, and she had a child. So now he's in the clink trying to get custody of the So after the all right, so here we go. This is a good one. So here's Mr. Millward. He was the teacher. And here's the student bottom left. Attractive. Manipulated, probably. And I show you the case in the clip, too.
Comments. I did
What's up,
brief
Bill
this.
Rhodes?
I won't belabor it, but I will summarize, partially for the defendant's benefit, the law. As our motion and brief summarize, both the Child Custody Act and the Revocation of Paternity Act contain protections for mothers like my client who choose to carry a child after they learn they are pregnant following criminal sexual conduct. The Child Custody Act states that.
So here's the case. So former sentenced to prison in student rape case. 20 years. Lying to intimidation of a video, was accused of being in an affair. She was 16 at the time. See, I want to be alone and spend time with my child. She said he's definitely is one of the best things in my life. And now he's fighting for custody.
In jail because he was already in pretrial detention at the time the child was born. The Calhoun County Prosecuting Attorney's Office filed this support action for child support and birth expenses.
Yes.
Unsurprisingly, as a teenager who'd been victimized by an adult and left pregnant, Ms. Blackman had to rely on Medicaid to cover the cost of the child's birth. When Mr. Millward answered the complaint for support that had been filed by the prosecutor, he requested custody and parenting time. It was left to Ms. Blackman to represent herself on those issues, and at the time, she was not aware of her statutory rights as a survivor of CSC. Ms. Blackman was granted sole legal and sole physical of the custody of the child, but the 2019 order left open the possibility that defendant could seek parenting time at a later date. That was an error. MCL 722-27A4 states that the court shall not grant parenting time to the offending parent. Ms. Blackman, however, did not waive her rights under the statute when that order entered in 2019. In fact, she cannot waive the protections except under the one very narrow exception that's defined in the statute. And that is if she had cohabitated with the offender after the child was born and raised the child with him, creating an established custodial environment for both parents. And that didn't happen. Mr. Millward has been in jail or prison since this child was born. He admitted in his response as much, and he therefore does not have an ECE with this child. For that reason, we ask that Your Honor immediately grant plaintiff's motion to dismiss defendant's motion for parenting time that's pending, and there is an evidentiary hearing that's pending on that we would like to have canceled and are requesting to have canceled when the motion is dismissed, and that you immediately enter an order revoking his paternity. The defendant's response that I received on Friday would ask this court to hold an evidentiary hearing regarding when the child was conceived and or whether the plaintiff waives the protections for survivors of criminal sexual conduct. That request should be denied. A fact-finding hearing is not called for in this case. Both the CCA and ROPA allow for a fact-finding hearing in certain scenarios where there has not been a criminal sexual conduct conviction. So if there'd never been a conviction, but only an allegation that there had been a CSC, then a mother could raise that allegation and ask for an evidentiary hearing for this purpose. But this case doesn't require an evidentiary hearing because Your Honor can take judicial notice that defendant was convicted of CSE against my client, not just in Calhoun County, but also additional counts in Branch County and St. Joseph County, all against Ms. Blackman. The defendant's response appears to rest on when he stopped being employed by plaintiff's school. It should be noted that he resigned once his conduct towards Ms. Blackman started to be investigated by law enforcement. It should also be noted that he picked up additional convictions for witness intimidation against my client by trying to stop her from cooperating with police. But Your Honor, this is not a criminal matter and this court sits in equity. MCL 722-26-1, a part of the Child Custody Act, makes clear that the Child Custody Act is equitable in nature and shall be liberally construed. Defendants' attempt to narrow the question of timing of conception is a distraction from this court's duty to interpret the CCA in an equitable manner. The purpose of the provisions for rape victims who carry their offender's child is to protect them from additional psychological trauma and to allow the child to be raised in a healthy environment without the interference of the offender. Furthermore, the crime of CSE by a teacher against a student has been found by our Court of Appeals to apply to offenses outside of a strict school calendar of employment. And People v. Lewis, 302 Mich. App 338, which I can provide to this court a copy of, given the late filing of defendant's response, the Court of Appeals found that a longtime substitute teacher's sexual penetration of a former student during the summer after he had been her teacher was a CSE under the same statute that the defendant was convicted of. The Lewis court found that more important than the timing of the offense was the occupation of the actor and the vulnerability of the student, and that wasn't changed by the fact that it was summer. People v. Lewis has not been overturned. It remains good law. There has been subsequent cases of CSE in the criminal context parsing how long after the defendant ceased being the teacher of the student that there might no longer be a conviction under the statute. But again, the CCA is equitable, and so that issue is not dispositive of his parental rights under the Child Custody Act. He might have found a strict statutory reading in his criminal matter about that timeline, but under the CCA and ROPA, the only way a victim of a CCA who becomes pregnant with the assailant's child may waive the protection is that very narrow one that I mentioned, that if she went on to cohabit and live and raise the child with him, and there's no evidence and proof, and there's an admission that those facts do not fit in this case. As we explained in our brief, there's no published case law related to these statutory protections. However, the statutory language is very straightforward, and in the only known case that's been reported in the media of a Michigan court granting paternity, custody, or parenting time to a convicted CSE offender since the passage of these statutes occurred in Sanilac County in 2018. And in that high-profile case, the judge vacated the orders and the prosecutor publicly apologized for the filing of the support case as soon as they realized they'd overlooked the offending parent's CSE conviction against the mother, who, like my client, was also a teenage victim. Your Honor, we ask that you do the same. The orders in this case should never have entered, and they must be corrected by entering an order now, revoking defendant's paternity and shutting the door that was left open for him to seek parenting time. Thank you.
Thank you. Mr. Millward, what's your response?
Yeah, I'd first like to say what happened back in 2018. I have empathy for the victim. I regret all my decisions, all my
Okay, sir, I don't need to know that. I need to know what's your response to the motion.
Yeah, so
shut him up.
Based on my understanding, Ms. Reynolds is right. If the child was conceived when I was a teacher before February 12th of 2018, then these laws would apply. I would never be able to get parenting time with Elijah, our son. However, Elijah was conceived in the middle of March of 2018. That was a month after I resigned as a teacher from Athens area schools. And in Exhibit A, I have that resignation letter from the superintendent that made my last official day February 12th. So after that, Shannon and I decided to continue our relationship. After I resigned, she was of legal age. The relationship was mutual and consensual. And her and I both agreed that Elijah was conceived on St. Patrick's Day weekend of March 2018. So I don't see how this Revocation of Parentage Act applies to this situation.
This is very interesting. As disgusting as he is, the legal side of it is very interesting because he makes a very valid point. If she was of legal age and does this law apply? He is a scumbag. I am not contesting that at all. Coming from being a teacher, he makes me sick. But the law is the law. And does this apply?
Unless he was conceived when I was still a teacher. The second part of the argument is that the plaintiff was under duress when she signed the affidavit of parentage. Now, our son was born in the middle of December of 2018, December 14th. I went to jail a month before that, November 14th of 2018. As soon as I went to jail, the attorneys, the detectives.
Oh, Hello Kitty. I agree completely that she was being groomed. But this is where the law is black and white.
They all made it very clear to me and my entire family. Absolutely no contact with Shannon or her family. We followed that. I remember the affidavit of parentage was brought to me when I was in jail by a jail lieutenant, and I signed it. And she had already signed it when I had received it. And if this were to go to the evidentiary hearing, I would have family members be able to testify that nobody communicated with Shannon to put her under duress, at least from my.
The law should just state if you had a child with someone that you had with previously in this type of position, no. There shouldn't be all this choppy black and white stuff. It should just be a blanket. You're gross, no kid. If the mother says so.
Side of the family to sign that affidavit of parentage. There are two main reasons I filed this motion back in March.
Get a rope.
The first is because parenting time was reserved at the end of 2019, and it stated that the parenting time section stated that my parenting time be reserved until the child attains a more appropriate age to deal with parenting time in prison. It was also around this time at the end of 2019 where Shannon reached out to my mother and asked if my mother could start watching our son on a weekly basis. Now, starting at the end of 2019, I started talking to my son on the phone on average, once per week when my mother had him, usually on the weekends. This lasted all the way up to the beginning of 2023. I attached an exhibit B, which proves that Shannon knew about this communication between me and our son, and she was actually excited that it was happening. Also, I attached exhibits C, D, E, C, D, and E, which show that my mother had temporary custody and power of attorney of Elijah for 6 months in the year 2022, specifically between April and October of 2022. Now, based on my understanding, because I haven't talked to Shannon in a while, and I can't contact her through the no contact order. From what I've heard, she actually she begged my mom for a couple weeks to take custody of Elijah temporarily because she was going through a very difficult time mentally. And emotionally, she had an abortion as a result of a abusive relationship with a boyfriend. Maybe not physically abusive, but emotionally and
Your Honor,
manipulative.
I would ask that he's talking about things he doesn't have any firsthand knowledge of that are outside the scope of the timeline that's relevant for this motion.
Sir, just stick to the facts and that, not anything that you might have heard or that can't be proven.
Okay. Yeah, based on exhibits C, D, and E, my mother had temporary custody of Elijah for 6 months. And it was during this time I formed a really strong and positive relationship with our son. I talked to him almost every single day on the phone, sometimes more than once a day on the phone. And he learned to know my voice. He learned to know what I look like through pictures. As soon as the phone number popped up, he said, "Daddy's calling." And we ended every phone call by saying, "I love you" to each other. Now, Shannon met a new boyfriend, had a new baby, and ever since then, she's been trying to erase my side of the family. And I just don't think that this Revocation of Parentage Act applies here because I was not a teacher anymore and the relationship was legal.
Okay. Anything else, sir?
No, Your Honor.
Okay. Ms. Reynolds, anything else?
No, only the clarification that my client remained a minor up until the time that the child was born. Because the child was born when she remained 17. So that there was not, she was not an adult at any point in time that before she had this child.
Okay, thank you. Well, the court does note in this particular matter, the undisputed facts are that the defendant was convicted of CSC third. He also was convicted of a witness bribing or intimidation or interference in this particular matter. Court takes those as undisputed facts in this particular case. Court would note that aside from his arguments that during this time when this relationship occurred, the plaintiff was always a minor in these particular matters, and obviously suffering under that legal incapacity, if you would. And as a result, the court does find that the motion is well taken. The court will grant the motion revoking the affidavit of parentage in this matter. The court will determine that the defendant is not entitled to parenting time pursuant to MCL 722.1455, and the court will further cancel the referee hearing scheduled in this matter. Ms. Reynolds, you can prepare that order and submit it under a 7-day notice of entry.
I will, Your Honor. Thank you very much.
That will conclude this matter at 9:14 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Wow. Kirkman laying the wood. So, go subscribe to WNN. They are savage. They're live. All they do is make fun of Chili. It's hysterical. They are time served approved. Here we go. Thank you very much for the memberships. Here we go. This guy hates his lawyer. Plain and simple. Is the lawyer a jerk or are you a jerk? Here we go.
My lawyer hangs up on me. That's not a lawyer.
Okay.
I like how my attorney
Mr.
just
Lee.
hangs up on me, and
Mr.
you
Lee.
guys just give me some guy that's supposed to represent me. He
Mr.
represents me.
Lee.
He ain't for me.
Mr. Lee.
Sorry, Your Honor.
Stop talking.
Sorry, Your Honor.
And then there's like a lot of noise going on too. I don't know what that was. This court is like time served audio. Needs work.
We're going to go on the record and file 23-14438-FH, people of the state of Michigan versus Charles Anthony Lee. Mr. Lee is appearing via Zoom from the Grand Traverse County Jail. Mr. Kane is here this afternoon as the MIDC attorney. We have Ms. Henry from the prosecutor's office. Mr. Herman is here for the department, but I think he's here for the next case. We also have court staff and clerk staff. We're going to conduct the arraignment via Zoom. Absent objection, Mr. Kane, let me go to you. You had a brief chance to speak with Mr. Lee in a breakout room. Did you have a chance to review the allegations against him?
I did not, Your Honor. He expressed that he had not committed any violations and a desire that his attorney, Mr. Burdett, help him with this matter.
Okay. Mr. Lee, did Mr. Kane at least have a chance to inform you as to what the allegations are? I understand you may contest them, sir, but I want to make sure you understand what the allegations are.
I didn't get a chance to speak with him at all because, you know what, he controlled the whole conversation because he pushed the button. Only thing I wanted to say was...
Well, hang on a second, sir. I don't want you to say anything that may implicate your case. So what we're here for...
I'm not guilty, plain and simple.
Okay, fair enough. I just need to make sure. Mr. Lee, stop talking and listen for a moment. It will greatly benefit you, I think, in life, let alone this afternoon.
I think it sounds like the door may be open in the defendant Zoom, and maybe the cops are talking.
There are allegations that you violated your bond by being in the presence of the victim on your underlying criminal case. As part of the bond in that case, you had a no contact provision, meaning you were not to be within sight, let alone 500 yards of that individual. Those are the allegations. Do you understand those?
Yeah.
Okay. And is it my understanding then that you wish to have a hearing and contest those allegations?
I wish to have Mr. Burdett available. I've been in contact with Mr. Burdett. The allegations that are against me were because she had warrants for her arrest.
Mr. Lee, okay. I don't want you to talk about the underlying instances because that can be used against you, sir. I understand that Mr. Lee, please listen. I understand that Mr. Burdett is the attorney on the underlying file. Today is what's known as an arraignment on a bond violation. The law was recently changed in Michigan, where the Michigan Indigent Defense Council Committee program has to provide an attorney for every defendant at every arraignment. Mr. Kane is one of the contract attorneys that's not assigned by the court, it's assigned by the commission to represent individuals at these individual hearings. If you would like to contest the allegations and have it set for a hearing, Mr. Burdett would assist you at that hearing. I just need to know how you want to proceed, sir. If that's the way you'd like to do it, that's perfectly appropriate. I just need to hear you say that rather than tell me what you want about the allegations.
Yeah, I would like Mr. Burdett. That's what it's like Mr. Burdett too. You know, I've been in contact with him since I've been out.
Okay,
this whole thing.
I understand you've been in contact with him. Do you wish to proceed to a hearing and challenge the allegations against you?
I really, the allegations against me on this charge, I really don't care about this charge because the whole case is going to get thrown out anyway.
Okay. Well, based on your statement, I'm going to
assume
and treat that as though you want to proceed to a hearing. So that's what we're going to do. Mr. Burdett, given that it's a bond right, Mr. Lee, please stop talking. Given that Mr. Burdett is your attorney in the underlying file, he would be assigned to represent you at that hearing. I think given the conditions of bond being violated in a domestic violence case, I'm not going to issue a bond at this point. We're not going to have any discussion about that. The hearing will be set within 14 days. Mr. Burdett will be in contact with you, sir. We're all set, Mr. Lee.
Sure will. Yeah, sure will be.
Doucher. This guy was an ass. Oh, gross. Okay. Guess what I got?
And for stepping in.
Okay. She doesn't fly off the handle, but she's pissed. So we know it's a recipe for disaster. Let's roll.
The one question I have, the two questions, I guess it's two questions, but maybe not, depending on what a question looks like. So Miss Callahan was also ordered to test once a week and to clear up the warrants in 47 District Court, and she had a show cause in 43rd District Court. Do you have any update with respect to those items?
No, Your Honor, I did see that when it was brought to my attention to give you an update. I did not have the time to look into that, but I can verify that if you give me time to do that, I can do that for you, Your Honor.
You mean today?
I can do it today. It's going to take me a minute.
Oh, okay, so that's fine. No, so do that for me, then I'm gonna adjourn I'm gonna withhold my decision at the moment. Okay, so I'll adjourn her, set her for review.
Okay.
Now, are you the probation officer or are you reporting for Miss, did they assign it to you now?
Now, I'm covering for Officer Williams, but I
Miss,
am.
okay, yes, okay.
Stands
All
mute,
right,
Your
thank
Honor,
you
waives
so
the
much.
reading of the information as
Do
to
you
plea
want
of
me
not
to
guilty.
just check back in this morning, or?
No, you can just send me the update because I'm gonna adjourn her, because I have a
Okay.
jury trial this morning, so I'm gonna adjourn her to another date so I can get that update.
Okay.
Okay, thank you, Mr. Hunter.
Thank you, Judge.
All right, have a great day.
You too.
All right, so with respect to Ms. Callahan, I'm going to adjourn her for review. And I will do that for next week. I know I'm booked, but I'm gonna squeeze it in. Tuesday. Mr. Flanagan,
Yes, Your Honor.
my jury trials on Tuesday are no longer
Thank
going.
you, Craig.
So how many do I have on Tuesday?
$23.
All right, so I'm gonna adjourn this to Tuesday, May 16th.
So, I just did a little something. I changed it up. Okay? I showed you the end. All right? Nice and calm. Defendant is quiet. Now we're going to go. And I'm going to show you why she called probation. Because somebody tried to be a smartass with Judge Bryant. But I'm gonna make you wait for that because I'm gonna show you this.
Sir.
Yes, sir.
All right, this will be ticket SP 11681581. Failure to display valid operator's license. This is a misdemeanor charge.
Thank you, Kim, for the membership. And we have a court nerd, frequent flyer, Trevor, my man, all day. I see him all day. I am happier in this chat, brother. Welcome.
Sir, maximum penalty you face is up to 93 days in jail and or $500 fine. I'm going to set aside the
Trevor
arrest
Preston,
warrant,
my man.
give you a enter not guilty plea on your behalf, and give you a personal bond. Your next court date on this will be June 12th in front of Judge Yancey for a pretrial here in 36th District Court. Now, on your other matter, this is case 0706523, State of Michigan versus Tyrone Bomar. Counsel.
Thanks, Judge Steve Benson. Good, Mayor. Glenn Bird on behalf of Tyrone Bowman. I'm trying to say right on the rights of constitutional rights.
Court will enter not guilty plea on your client's behalf as to bond.
Thanks, Judge. The people have reviewed the investigative report. People would also like to note this is a 2007 case. Defendant at the time was 25 years old, which would make him approximately 40 years old right now. As a result of all of that, including what happened in this matter, the people don't object to it. Oh, Judge.
Thank you.
A hush falls over.
All right, sir. While this case is pending, you are to have no contact with Mr. Crum. Is that clear?
Who is Mr. Crum, sir?
The person you're alleged to have assaulted many years ago at the Chase Bank on Dexter, sir.
What year was that, sir? Mr. Bomar, this is your attorney, Brandon Burr. I just asked a question. What year was that?
Who that?
I understand you asking the question. I'm gonna ask a question too. Can you please exercise your right to remain silent? We got you taken care of. I'm trying to get you out of here, okay, brother?
Look at his face.
All right.
07, I most definitely don't remember that. Okay.
All right. There is a capias in the file from 2021 at 510%. For missing a pretrial. Apparently, in October 2021, my former colleague gave this gentleman a $20,000 personal bond. And then there's an older capias dating back to 07, where he missed pretrial then. Sir, whether you remember this event or alleged events or not, you need to show up to court to get this case resolved and behind you. Is that clear?
Yes, sir. Most definitely. It's crystal clear.
Okay. Court's going to set bond at $5,000 personal. Next court date will be a pretrial in front of Judge Bryant on July 5th here in 36th District Court.
He's going to
Thank you, sir. You can step aside.
So what if I don't have the money to bind out?
No, it's a personal bond, sir. You don't have to pay to get out. Just make sure you show up to the next hearing.
Okay, great. Thank you, sir. So I'm about to leave.
July 5th. Yeah, Madam Clerk, can you redo the minutes on that? They were
Okay, here we go.
Miss Stevenson.
Stands mute, Your Honor, waives the reading of the information as to the plea of not guilty and on her behalf, and that the matter be rescheduled for review, Your Honor.
Well, let me.
I think the balance is 0, Judge. I just don't know
No,
about the other.
that's what it says, but that's wrong.
Oh, okay. Okay.
Do you think she knows she's gonna get yelled at?
Mr. Flanagan, I just sent Mr. Torres an email regarding Mr. Torres and Mr. Hunter regarding Ms. Callahan. They were supposed to provide me an update. I just asked them if there is one yet. Ms. Stevenson, I had an opportunity to, at the very minimum, to review the register of action, and I didn't understand what I saw in the financial screen. So in the financial screen, it indicated that the total fines and costs were $600, but clearly that is not correct, because when you go to February the 27th of 2020, Judge King sentenced Ms. Callahan, and the total fines, costs, and fees were $950.
I see that, Your Honor.
So if she paid $600, she owes $350. And then additionally, she came to see me, and it said something about a supplemental sentencing for 6 months. That was back in 2021. And then she was supposed to attend the victim's impact panel, view the consequences video, submit to urinalysis once a week, complete inpatient treatment. And then I said, any violation would result in a Wayne County jail. And then she was supposed to clear up 47 District Court. She had a show cause in 43rd District Court. And then she was supposed to come back to see me March 1st of 2022. And then she came back to see me March 1st, or something happened March 1st, because then I made her come in person. She came, something happened on March 1st, and then on March 8th, she was supposed to come in person at 36th District Court, and she did not. And, that's where we are. She did not come in person, and she has not been submitting to urinalysis. And it sounded to me like she doesn't want to do the probation.
So, Ms. Callahan, hold on just a moment, ma'am. So,
Okay.
Your Honor, I would like an opportunity to look into all that, and I'm looking at
Look into what? That she didn't
the-
come in person when I ordered her to do so?
definitely
That's the
not
only
that.
thing I'm looking into. I ordered
Mhm.
her to come in person on March the 8th of 2022, and she said, nah, I'm good. That's exactly where I'm at. I'm stuck right there. Like, you're not gonna be able to tell me anything else.
I
That's
think
where
they're
I'm stuck. Okay.
Yeah, I'm gonna have an answer for that, Your Honor. I just don't have it right now. But there are some peculiarities going on. I know that there was initially, so I think the balance really is zero because there was a $500 bond that was
Forfeited.
incorrectly, but then I think it was your order that it should not have been forfeited. So it did get applied. And then there was an additional, $600 payment made. So I think that there is something more going on here. Certainly,
Well,
I don't have
when did she make the $600 payment then? Where do you see that at?
So I see that monetary transaction div dat payment November 19th, 2021, I think.
November
11/3. Yeah. That's the 11/30/21 date.
I don't see what you see. You said
11/30/21. There's a note. It says monetary transaction div dat payment November
okay.
20.
Okay, I do. Okay, I see that. All right, so the balance may be properly zero.
Or even maybe a credit or something. I'm not sure, but I do need to. I'm not going to have anything to say about the failure to appear in person as ordered by the court. But I do at least want to find out whether or not the other conditions have been complied with.
All right, Mr. Hunter has said she completed the victim's impact panel. She completed the consequences video. She paid the fines and costs, and she completed inpatient treatment. There's nothing on here about the warrants, so I guess he didn't pull them up.
Okay.
And we know she wasn't submitting to your analysis once a week.
Right.
Okay, so what?
Well, I mean, I know that the court takes its orders completely seriously, so I do need to offer an explanation for the urine analysis and the failure to come to court in person, which I just don't have at this time, Your Honor. But it looks like for those issues,
But for those two major issues?
two very, very crucial issues, looks like we have come out.
Not without some explanation. So maybe you need to go back in the breakout room, because number one, I ordered her to come in person. And she came in. I'm telling you, I'm not, hospital, jail, funeral, something. Because other than that, she violated my order, and I don't care about anything.
Get that answer, and then we'll get that on the record.
Sure, or something.
Okay.
And why she hasn't been submitting the urine analysis.
Here he is. He's probably here. Johnny on the spot with the answer right now.
He doesn't have it.
I always have it, Judge. Actually,
Always.
with regards to Ms. Callahan, I would advise she was actually
You gonna put your
incarcerated.
appearance on the record?
Ride Marat for the record, Your Honor, P83665, with and on behalf of Ms. Michelle Callahan, who's present on Zoom. Your Honor, my apologies to jump in, but I just would advise Ms. Callahan was actually incarcerated on another matter. Prior to her incarceration, she was doing well. She does have some proof.
What date did she go to jail? Was it
I have-
after March 8th, 2022? That's what I want to know.
Yes, it was, but very
So
shortly
then
after, Judge.
therefore, why she didn't come, listen to, this is my question.
Yes.
This is my question right here. I ordered her to come to court in person March the 8th. She's supposed to come March 8th of 2022.
Judge, I'm going to switch places with Mr. Murad, if that's okay.
Yeah, sure.
Okay, all right, okay.
I ordered her to come in person. She didn't. I'm stuck right there. I'm stuck right there. I want to know why she didn't come to court when I ordered her to do so.
Judge, you are correct. She did not come to court on that day. I don't have an explanation that I believe would be appropriate for this honorable court, but I can tell the court this. She was juggling another matter at that time where incarceration became a real threat. I don't believe she really leaned into her bond conditions, into what the system wants her to do and what she was supposed to do and what she was required to do. I think she neglected that, Your Honor. And because of that neglect, she did find herself in the Oakland County Jail for almost a year. Prior to that, Judge, she was doing okay. I think she fell off when she realized that she was not in compliance and she could go to jail, and that's exactly what happened. But prior to her going to jail, Your Honor, she did work with the Mothers Against Drunk Driving Victims Impact Panel. She's built rapport with Ms. McCall. I'm pretty confident, Judge, if the court considers forgiving her for her non-appearance that day and allowing...
I don't have a valid reason, and I'm not, because let me tell you who is not more important than me. Oakland County judges. They're not more important than me. Their orders are not more important than mine.
I agree.
So, I mean...
I don't believe she followed that order.
There is a reason that I don't know right now, of course, and I didn't pull out my notes, that I had her come on in person. So I don't know what the reason is, but I had her come in person, and there is also a reason that initially, that at some point in 2021, I said any violation of the probation was going to result in her going to the Wayne County Jail. I don't do that. That's not my normal thing that I do. So I put that in the order. And I haven't heard any reason why I should veer from what I said with Ms. Callahan.
Your Honor, I think I think the court did that because the court was aware that she had another matter pending as well, in the same nature. And I think the court was not pleased with the fact that she was fighting two cases of similar nature in two different jurisdictions. And the court felt that she was going to get the benefit of, probation, that she better be on point and in full compliance. And Your Honor, I guess based on her non-compliance with the other jurisdiction, I think she did the 36th District Court probation, at least a good chunk of it, Your Honor. I think she was slacking in the Oakland County probation once she learned, I think, and this is my assumption, but I think once she learned that she was going to be, I guess, held accountable in Oakland County, she stopped responding to Detroit until she was already incarcerated. She was writing the probation department and the court from the jail as well. She's actually received communication from the probation department while she was incarcerated. So I know that she was taking steps to comply after being incarcerated, but Judge, no, I don't have a valid reason why she didn't come on that March 2022 date. I don't. But I think with the compliance that she's already demonstrated on this case, the fact that she's had to go through a horrible thing like a year in the jail, in the Oakland County jail, and I understand the court's position there, Judge. I understand why the court would feel that way. But the person I met in the breakout room was somebody who has their record, somebody who wants to come into compliance, somebody who's apologetic. She hasn't missed court. So she got out on the 23rd, Judge, of March this year, and she's already in court in May trying to handle this. She didn't take any time off. I'm hoping the court would maybe give her one chance here to at least set this for a review, let the probation department confirm whether or not she's being truthful and she has actually done some of these things. And maybe we can give her some of the tools to make sure this never happens again. I think she would be a great candidate, Your Honor, if the court would just consider setting this for a review and giving her one more crack to finish and be discharged with this probation.
Okay, here we go. So I am letting you guys pick the final one. Make sure you hit that like button. It helps us out a lot. Here we go. Judge Stevens. I know a couple people played, though there was one, but there was another one in the afternoon that was even just as good. Steven's giving life lessons is fantastic.
Mr. Spurlock? Daniel?
What's up, Richard? See you. Thanks. Just want to say thank you to everybody coming into the chat, hanging out. We have fun here. Let's roll.
Six cases, apparently. Six, okay, or three of them going to get dismissed, is that the plan?
Yes, sir.
Okay, so it looks as though we have 22-4118, second degree felony of escape that you had pleaded guilty to back in April.
I didn't leave you guys hanging. I played you the beginning first. Yikes. Because the second part was just the probation officer talking. It wasn't anything. So I showed you the first part. Because Brian calmed down, saw a couple of the people, brought her back. I showed it to you already. You go back if you want to. So the first part was the gem. Brian was awfully calm today. Guys, don't.
Then we have 41120, unauthorized use of
She
a motor
never
vehicle.
spoke.
Is that to be
The
dismissed?
woman never opened her mouth once.
Then 41288, burglary of a building to be dismissed. 41290, burglary of a building, the defendant pleaded guilty to in April.
Yes, sir.
And 41292, retaliation for which the defendant pleaded guilty.
Yes, sir.
As well in April. So those are the three cases, and the defendant is present with Mr. Adams, his attorney. Again, earlier, the defendant has pleaded guilty in 22-41118, and that again is the second degree felony of escape, and the sentence is whatever sentence shall not exceed a cap of 6 years in prison. So he's looking at no less than 2 nor more than 6 years confinement in prison. I guess deferred or unadjudicated probation. He is not disqualified from that. And then regular probation as well. And you understand all your options there, and it's been discussed with you by your attorney.
Yes, sir.
Then burglary of a building, a state jail felony, and whatever sentence shall not exceed a cap of 15 months in the state jail. So you're looking at no less than 180 days up to 15 months, deferred or unadjudicated probation, and regular probation as well. In that as an option. And finally, 41290. I'm sorry. 41292. Retaliation, and that's a third degree felony. So the sentence agreement was a cap of 6 years in prison. You were looking at no less than 2 nor more than 6 years confinement in prison. They're also deferred, as well as regular probation is an option. All right, do you understand all of those?
Yes, sir.
And then 3 cases will be dismissed as part of this agreement. All right, a pre-sentence report has been prepared. If the parties had an opportunity to review it, and are there any corrections or changes to it? Defense?
No corrections or
And
changes.
state?
Nothing from the state, Judge.
All right. Go ahead, Mr. Adams, on behalf of Mr. Spurlock.
All right, Mr. Spurlock, are you asking the court to give you probation, deferred adjudication on these 3 offenses? Yes, sir. Now, if we go to page 2 of the PSI, you take responsibility by saying, to be real with you, I was not having the best day. I do not think, I did not think before I did anything that day, and I regret it. That's the day CPS let me go. I really don't think I had anywhere to go or live because I never called my mom. And she did not say when I got out of jail, I could come live with her until I get on my feet and feel like that would be really good for both of us. So when we talk about CPS, how old are you right now? 18, sir. And with you being 18 years old, it is to my understanding, since you were 5 years old, you have been in CPS care, is that right? Yes, sir. So for giving Judge background as to what led you here today, at 5 years old, were you taken from your mother and your father? Yes, sir. And being taken from your mother, did your mother suffer from mental illnesses? Right? Yes, sir. Bipolar and other type illnesses, right? Yes, sir. And then your dad, his home wasn't stable, was that right? Yes, sir. So with you going into CPS care at the age of 5, just so the judge can have an idea, how many different placements did you have while in CPS? I would say 20 to 25. And when I say placements, when we say 20 to 25 placements, that means from a 5-year-old on up to an 18-year-old, you've had about 20 to 25 different homes, right? Yes, sir. And that's while you were in CPS care. Yes, sir. And are you saying that when we look at some of your criminal history, just the things that was going on with your life, you didn't make good decisions, right? I did not, sir. But today I look at you, you're 18 years old, right? Yes, sir. At least the times that you did get in trouble while in juvenile, I think for the probations that you had, you completed those. Yes, sir. And as far as your adult history, and when I look on page 4 of your adult history, you got the pending cases, right? Yes, sir. And then when I look at the on evading, that was a few dismissed, to be dismissed, to be dismissed. So you haven't had an opportunity to be on adult felony probation in your life.
Hold on, I'm gonna have to lodge an objection on that.
I'm reading right here.
What's number 1? What's number 1 on that page?
Oh, never mind. My bad. My bad. I didn't see that. I'm just reading as I can.
Nice try.
Okay. My bad. But so, well,
I mean,
you did have
that was just, he was placed on probation. I mean, that's the elephant in the room here.
Right.
He was placed on probation in February of last year.
I didn't see that.
And then thereafter, these 3 crimes were committed in a few months while on probation.
So, well, let me explain.
Work on that. That's the elephant in the room. That's the problem.
I didn't see that.
That needs to be addressed. Okay.
So if you look at the unauthorized use of vehicle, and I see Angelina, Texas, it says MTRP pending. You got 4 years deferred adjudication. What caused the MTRP in Angelina County? Do you know? I do believe CPS released me on the day that I get that warrant out for my arrest. So. Okay, so when we look at, I didn't know what to do. I didn't know if I was supposed to call or do anything. And to be honest with you, I did call. They said I had a meeting, but I had no logical ride to get there. You didn't have any logical ride to get there, you said? So. Okay, and what are you asking the judge to do for you here in this particular case? Let me know I'm not the same. I'm owning up to what I did, and I know they're not right. Right, and then with you being in and out of foster care 20 to 25 times, as you stated, issues with your parents, has that affected your decision making? No, sir, not at all, because I have my aunties willing to take me in and do what I need to do. And she said, as long as I do what I need to do, she wouldn't have no reason to turn her back on me. Now I see on page 4 where it has educational employment history, educational. The defendant reported he attended Sterling High School in Houston, Texas through the 9th grade, and he was working towards getting his GED, but did not complete the program. If you're given a community supervision, would you complete and get your GED? Yes, sir. And would you be willing to go and be a productive citizen and go out there and work? Yes, sir. And I see that you have worked before. It says McDonald's for about 6 months in 2022. Yes, is that right? And you're just 18 years old. Yes, sir. So due to the nature of your history with CPS just being released, you're only 18 years old right now, right? Yes, sir. Are you asking the court to the judge said the elephant in the room is that, hey, you got 4 years deferred adjudication in Angelina County. And now you're asking for probation in these cases. Why should he do that? That's a why.
Yes, sir.
I'm asking you why.
Because I have a stable home and I'm not the same as I used to be. I've grown up. I've learned from my mistakes and I'm moving past them. I'm willing to work a job, get my education and do throughout life what I need to do because there's a reason I'm here and I'm gonna find it.
All that since December?
Yes, sir. You're Jefferson County.
How old were you in December?
17.
Uh-huh.
I was 18. This last December I was 18, sir.
Look at Stevens. He's like dropping his head.
Had a lot of time to sit down and think.
I love the Stevens cam.
And how long have you been in custody, at least on these cases?
Since December 2nd.
I feel bad for the kid. I really do.
Keep going, go ahead.
So I guess the plan would be if you are released and placed on community supervision, would you go get a job?
Yes, sir.
And then would you have a place to go?
Yes, sir.
And specifically, you would go with
my auntie.
Okay, so you go with your auntie, you'll have a job, and are you basically saying that you got your head on your shoulders, right?
Yeah, guys, I don't know. This was Stevens cam. It goes back to the defendant. I don't know why it was just sitting there. That was court. So.
And you can do this right.
Yes, sir. And I just want another thing.
Okay. Is there anything I missed that you want to say that I didn't cover?
And if it's okay with you, I would do weekends.
Well, hope you talking
hope to do weekend.
Well, hopefully you get probation. Are you not?
Crimes going back from his juvenile days, 2015, 2016, 2019, 2021, and he continued as an adult into misdemeanors and into felonies. And then once he's placed on probation where he can get help, he just thwarts it and does all these things, which could have cost him.
Oh, these are terrible things.
Yeah.
Okay. Okay.
I'm asking for the 6 years, Judge, and the 15 months. The cap.
All right. In summary, here, what I'm looking at is someone who was put on notice that committing crime is serious, and you were on probation February a year ago out of Angelina County for unauthorized use of a motor vehicle. So come here to Jefferson County and we start here with October 19th, which would have been nine months or so, 10 months, I'm sorry, 8 months after you're placed on probation. And you are charged, you end up getting charged on October by committing a crime on October 19th, 2022, felony escape. So the here in Fort Natchez, And police are looking for your vehicle traveling at an extremely high rate of speed, and they attempt to catch up with you, and you crash into a house on Lazy Lane. I'm sure that caused some damage and some loss here.
You think?
And you, as the police arrived, Nederland Police Department there arrived to assist with the Port Neches, and then you jump a fence and you were detained after a chase. They had to chase you down there. So some kind of a relationship with a girl that apparently that went sour there.
Yes, sir.
And you forced entry into a home, unlocked the door, and then got her car keys, entered her car, and left without permission. The complainant, the lady, said, you say, if y'all couldn't work out the problems, then neither of you would make it home alive. Well, I'm pretty good with English, and that's a threat to harm everybody. So after a while being at the hospital, so you're transported to the medical center, then you escape from the hospital, somehow got out of handcuffs, and
wow,
were found nude underneath a truck. So that's an interesting night while on probation, with a case pending in this court. Then the next set of events happened in November. So what I don't understand is what happened in October. How did you get out of custody? Did you post a bond or something to get out?
No, sir.
No. You weren't arrested in October?
You talking about on the way to the hospital?
That night, when I just talked about those facts?
The officer had me in no handcuffs.
Were you arrested that evening? And brought to jail? Okay. So you had to have posted a bond to get out of jail?
Get out on accusation.
So there was no bond?
No bond.
What up, Chris?
So,
oh, wait.
There's a
Chris
case.
needs something.
They're working on a case, apparently. And then on November 10th, which would have been 3 weeks later, they're dispatched to Prutzman Road in reference to a burglary. And apparently there's evidence that a building had been broken into. And they have surveillance camera, which showed 2 people jump a fence and are looking through drawers, cabinets, and shelving. And apparently you're one of the people. A job application you had apparently previously filled out had been recognized by the people who had been burglarized. So they go to your apartment, the police, and detain you for burglary of a building and transport you to the Jefferson County Jail. That's on November 10th.
No, sir.
Sorry, the pre-sentence report has been admitted with, I guess I should have asked you what the mistakes were. But it says officers detained you for the offense of burglary of a building and transported you to the Jefferson County Jail. That's not correct. That's not correct. Then on November 11th, police are dispatched to 6550 Phelan in reference to threats being made. when residence owner returned to his apartment, he finds that it's been burglarized and property taken. And the phone charger belonged to you. You must have been the one who burglarized the apartment. After the crime was reported, the complainant here on this third occasion of events received a message. The message came from Omarion King. That's you, right? Don't act like you don't know what we're talking about. That's you, isn't it? All right. Known to be an account held by Daniel Spurlock. I'm sorry, Mr. Poindexter, do you know him?
Yes, sir.
He's a black man, is he?
No, sir.
He's not?
No, sir.
He's not. He's not African-American man?
No, sir.
You use this kind of language to talk to him, which is terrible language, insultive. You're calling him a curse word, referring, really? You refer to him with that slanderous racial epitaph?
I had 2 phones.
Yeah, is that yes or no?
No, sir.
You don't call him
No, sir.
this NIGGA word that I even hate to listen to?
No, sir.
You don't call him
No, sir.
this NIGGA word that I even hate to listen to? But it's a message.
With all due respect,
It's a message.
You see the color of my skin, so I wouldn't. use
Hey,
that language.
do you want to answer the question so we can move along with this hearing? Did you refer to him in that way, sir?
No, sir.
Okay. Message came from Omarion King via social media, Instagram. You've already acknowledged that's you. And it says, hey, bro, look out. We both know that you snitch. So you N-word, you refer to, you blank me, and lo, gonna come through your attic tonight, just like we did today, and cut your throat. So watch you back, N-word. Well, isn't that interesting? We did today and cut your throat. So watch you back, N-word. Well, isn't that interesting?
It wasn't me, sir. May I speak, please?
I
had 2 phones in that house.
I'm not through with you. I know you like to control your surroundings and environment, but you're going to follow the rules when you're in this court. And I'll speak and then you get to speak. If you don't want to follow the rules, we will gag you. Do you understand? So you don't interrupt rudely. Is that clear? It's real simple.
Special.
Your response to the probation office about all of this. To be real with you, I was not having the best day. I did not think before I did anything that day, and I regret it. Is that true?
Yes, sir.
According to the police, for this particular defendant and the crimes that he committed, I would like to see him get the maximum allowed punishment for each. During his crime spree on the night, he stole a car, fled from officers, crashed the vehicle into a house, injured an officer during his second escape attempt, showed absolutely no regard for the safety of others. His only concern was his attempt to get away from us, which injured an officer. That's not very good here. It doesn't help you very much. All of this, remember, is happening while you're on probation. Right? Correct?
Yes, sir.
All right, y'all. Anybody else want to add anything?
Judge, I know it sounds really bad.
Well, it is bad. It sounds bad because it is bad.
The only thing I would say on behalf of my client is that with him being 18 years old.
Oh, he's young and stupid?
Well, I'm not gonna say young and stupid.
Is
I'm
that
just
it?
saying.
Foolish? No, you know better.
I know
It's, you made choices. No, we're not talking, you're not a stupid person.
And I'm owning up to them, sir.
Well, I wish you would have owned up to them when we first had you in a courtroom and you had to realize how important and serious things were. My goodness. But what you're doing here is just free falling out in the public.
I was scared. I feel like I ain't had nobody to look up to.
Huh?
I was scared. I feel like I ain't had nobody to look up to. I was acting off of impulse.
Well, I mean, you knew better. You knew right from wrong.
Yes, sir, I did.
All right. Look, everybody's got their own story of life. But we try to fix mistakes when we make them as soon as possible. And here, when you get into court, there's the aura of seriousness. And I know Angelina County isn't a joke. They don't hold their courts as a joke. They're serious about the way they conduct things. But you came right out of the box and it's just your actions were inappropriate. You have vulgar language. That's no way to talk to people using vulgarities. It's indecent. But you know that. Oh, it's just whether it's a temper tantrum or immaturity, it's time you grew up. And you're 18 years of age when you're committing these crimes, right?
Yes, sir.
And that's an adult. And you got to act like an adult, or else you're held accountable. It's just a mess was made here. But what we have is you're on probation, then you commit another crime, and then just days later, you're committing a third offense. But I know you had to realize how serious everybody was taking this, and you're stealing cars, crashing into buildings, burglarizing buildings, retaliating, threatening people. It's a bad deal. There's no way to welcome adulthood. But whether you like it or not, you've got to act like an adult. And that means when you commit mistakes, you're going to be held responsible like an adult. You're not a child. All right, go ahead. I'm talking. Anything else you want to add? He wanted to say some things, I think, right?
Just wanted to apologize to
Well,
you and to your city.
Sir?
Said I wanted to apologize to you and the city and the people involved.
It's better to make the right choices from the beginning so you don't have to come back and try to fix things that you can't repair. You can't undo that. This probation in Angelina County had it been transferred or courtesy supervision here in Jefferson County? No,
I haven't heard nothing from them, so.
well, you were put on probation on this day. You had to sign something, deferred order, right? And
My CPS,
did they let you leave the county?
with my CPS worker, yes, sir.
They let you, how long? Oh, I got them. I have a Beaumont address and one indictment, but Port Neches address and another indictment. Where was your home?
Didn't really have one. That lady was
Well, what did you tell them in Angelina County? Where did you tell them you lived?
CPS. Because at the time.
Well,
I
what's
was
the
in
address?
CPS.
What's the address? What city?
1501 Betty Drive, Lufkin, Texas.
Lufkin. Oh, so who's in Lufkin?
It was a CWAP house child without placement.
Okay. They haven't completed, hasn't completed this NTRP. I guess you're going to be transferred up there to finish this.
It should.
So, once again, let's go over where we're looking at here. We have 3 different crimes. The first one, 41118, is felony escape, which is a 2nd-degree felony. And the agreement is a cap of 6 years in prison on that we all went over. And the next is in numerical sequence is the burglary of a building in 41290. And that is 15 months state jail. And finally, the 41292, which is 3rd-degree felony of retaliation. Where is the restitution in this?
There's $500 on one case.
Is that it? Is that all you had?
Or no, that's all I've had requested. It was on.
Which one is that?
23-41290.
Burglary and building.
Yes, sir.
What how much credit are we showing here on this particular case, please?
What's he gonna do?
Anything else? If not, by anybody, I'm going to find in each of these cases, Mr. Spurlock, you have pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. Mistakes Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. However, this is what I'm going to do. In 23-41290, the state jail felony of burglary of a building. You were hereby found guilty beyond a reasonable doubt. I'm following this sentence, and you were sentenced to 15 months in the state jail. Is that the one that had the restitution?
Yes, sir.
I'm going to also, on these other 23-41292 and 41118,
throw.
Even though there is enough evidence to find you guilty beyond a reasonable doubt, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years to run concurrently with that sentence. You will pay restitution as part of this package here to the person who was the victim in the 41290 of $500, and we will get that to the probation officer. There will be terms and conditions of probation, each of these felonies. One of them is a 3rd-degree felony and one of them is a 2nd-degree felony. If you fail on your deferred or unadjudicated probation, your probation can be revoked. You can then be found guilty and sentenced up to the full range. Right, everybody? The full range.
Right,
I want also some terms and conditions of probation, which I think are necessary for his inability to keep himself composed under stress, is the best way to say that. And I'm not sure if those are addressed in these or not, but we'll see.
My crazy. Played your corny clip. He did get 15 months in jail, though, guys, not just probation.
You'll be given credit for 180 days service already. But you're going to fix this mess by restitution of $500 as to $41290. There will be terms and conditions of probation that you must follow, including completing your high school education, remaining off the premises where these crimes occurred. You will complete a moral reclamation therapy program, which is learning to make good choices under situations where you have choices to make of a right choice and a wrong choice. In other words, it's maturity, growing up, where you need to be. Submit to an alcohol and or drug screening to make sure that there's not an issue concerning substance abuse. There are no fines on these, I don't believe. There will be other terms, conditions of probation. And again, you got to pay a price here, but you're going to also get help.
Very cool.
Shame on you if you don't, make good use of this.
Your choice.
You can't do all of this and sashay out of here with just deferred probation on everything.
He said
So you had your
sashay.
chance, like everybody, and you got to be treated like everybody else. Everybody knows when they're put on probation, they are high risk of punishment for failure, and that's what you and everyone else on probation have to accept and appreciate. There will be 3 cases. There was 3 cases to be dismissed. It's 41119. The case is dismissed. Let me just say this, I'm trying to look at trying to make things simple. And there are really three things you need to do to stay out of trouble. Three things. That's live honestly, harm no one, and give each person due respect, which is what you'd want. We all want. We all did that. Nobody get in trouble. We'd live happily together. But in each of these cases, you failed on each of those. And that's all law is based on one, two, or all three of those. And most importantly, that last one, respect each other. You better learn to respect each person. Everybody is entitled to respect, and you don't belittle a race by using it as a derogatory term when you're trying to insult somebody. That's atrocious behavior and unacceptable in an enlightened society that you're supposed to be living in. All right. Anything else? Do much better.
Scourge.
If you don't, you'll be back.
This kid is Scourge.
I'm not going to be as happy to see you back if you fail. So be successful.
Be successful.
Next.
Get out. You notice there's someone in timeout. Someone in timeout. Someone's in timeout. I didn't get the timeout. All right, people. Thank you very much for watching. I still have a ton of clips. Make sure you check out my last two uploads. I kind of changed the format a little. Thank you for following. Thank you for hitting the like. Thank you for just being you. God bless you, everybody. Make sure you check out my girl, KCC, Miss Kitch, going live tonight. Big things down the pipe. Possibly I'm alive with someone overseas. He's not from the States. I don't know. Maybe going live with someone. So let's piece that together. Just saying, dropping hints. All right, guys. God bless. Never go to bed angry and greedy. Kiss your loved ones. See you tomorrow. You've been scourged.